we're going to dive into a topic that's really important. It's in the area of FL, Federated Learning, and AI regulation. We're going to take on one of the topics that Tim asked us to really dive into, and so we've taken on board this, this challenge and found for you two experts in this area. Let me introduce them to you. The whole idea here is to make it interactive. So while I'm speaking, start thinking. And so think of a few questions, what you want to know. We're going to look at this AI regulation space. Let me introduce these two people. So right down here we have Bill Marino. He is a non-practicing lawyer. He is a visiting lecturer at Cornell. He is a startup founder and spent 5 years doing tech at Adobe. And currently, he is studying for a PhD in AI at the University of Cambridge. So thank you, Bill, for joining us. We also are joined here by Charles Kerrigan. He is a partner in the finance team and part of the specialist crypto and digital assets team in CMS London. And they specialize in emerging technology, including crypto, digital assets, but also decentralized AI and finance. And he's a very modest man. I saw this amazing quote about him. It's from Legal 500. They say that Charles is a creative, but risk alert and practical lawyer. So I think you want all those ingredients all in one person. So with that as an introduction, I think we can kick things off while you still are thinking of things you want to know. And so I'd invite them to maybe just give us a bit of a landscape. So even before we dive into these subtopics of AI regulation, could you both speak to things such as what is the EU AI Act? Let's spend a couple of minutes, 2 or 3 minutes, explaining it at a high level and discussing the risk topics and so on, all the major kind of things that kind of lay the landscape for questions that I'm sure people in the room want to know about.
Yes, thank you so much, Nick. Are you going to join us, Tyler? Are you going to sit?
No, I'm just gonna. Yeah.
So with Charles's assistance, we thought I would open up and just sort of talk about the EU AI Act and what is it, at a super high level. I think this is probably something that anyone who's going to be putting things on the EU market anytime soon or might be creating models that are downstream going to be put on the market in the EU will want to know about. So at a very high level, this was just ratified by part of the EU. This was just passed, I should say, this week, yeah. 2 days ago. Yeah. So this is hot off the press. They ratified the text of the act. So it looks like it's probably coming later this year. We'll start to see it go into effect. Is all of that accurate, Charles?
It is. That's right.
Okay.
Cool. It's brand new, but we've seen it coming for 3 or 4 years, so we're pretty well used to it.
Okay, great. So at a very high level, this applies to this sort of slices and dices the world of AI in a couple different ways, but there's really two, I think, key paradigms that everyone ought to know. And one is AI systems, and I do have the definition on my phone, so I don't mess this up. But the way AI systems are defined are, let me see, there's a lot of definitions in this act. So get ready for all of those.
And it's not the only definition of AI. Every standards body, every regulator has got their own. But this one will probably become more important through more use and reference than others.
Absolutely. So the way it defines AI systems at a very high level is machine-based systems that are designed to operate with varying levels of autonomy and that take some input and then infer some output, such as a recommendation or a prediction. So that's AI systems.
And I think one point I always make in this when we're having this conversation is the definition. So regulation is written broadly so that people can't game it. And often it's written in overbroad sense. And there was a lot of debate around this. But you guys would see this definition and think, well, it sounds a lot like algorithms without much learning in them. So this is a very broad regulation. Yeah. It's coming for algorithms that have self-improving characteristics, but it's wider than that.
So it goes beyond machine learning per se. Okay, say. So with AI systems, and we're going to talk about the other paradigm, which is general purpose AI in a second, but with AI systems, the key kind of thing that you need to know is that they slice and dice these according to risk level, with the riskiest being prohibited And these are things like manipulative systems. So those are just, cannot do them. And then there's high-risk systems. And this includes safety features of products that are already regulated in the EU, systems that are themselves products that are regulated in the EU, but also items, or I should say use cases from a list that are clearly specified as being high risk. And this includes things like education, chime in with a couple others, critical infrastructure.
Exactly, yeah.
And so these are the subject of a lot of the rules in the Act. These are, you could say highly regulated maybe. And there's a lot of rules around data governance, human oversight, documentation, technical documentation, and a number of other requirements. The other paradigm, and I'll mention briefly, and then we'll say a couple other things and maybe get into it. I'm sorry this part is taking so long, but hopefully this is very good background for everybody. You're definitely going to be hearing a lot more about this. Is general purpose AI. So most of us would call this foundational models, right? So this is models that have a wide variety of downstream use cases, broad applicability. And these are, again, kind of divided into just general purpose AI and then general purpose AI with systematic risk. And this is kind of, in my opinion, muddily defined, but this is, systems with higher impact based on benchmarks. The amount of compute that it took to train the system is one thing you can look at to decide whether or not it falls into this category. And so, between the two kind of buckets I just described, obviously the latter bucket is a little bit more heavily regulated. When it comes to general purpose AI systems, a lot of the rules are around documentation, transparency. Important exceptions in the Act. Research and development is an exception. So this is mostly about things that are on the market, being used commercially. So that's obviously relevant to a lot of the people in this room. And then open source has sort of a semi-exception, right? I think, correct me if I'm wrong here, but open source, the rules do not apply unless you are high risk or unless you are, you have systematic risk in the case of general purpose AI. Yeah. So that's very high level. Most of these rules are the responsibility is borne by the model providers, which is a way of saying the model developers. But the downstream users, like fine-tuners, can become developers, and therefore the onus is on them. Anything else you would want to add at a high level?
No, I think you've got it exactly right. So a jurisprudence point here, regulation, it bans things, or it permits things subject to conditions, or it prevents some kind of people from using the thing and other kind of people can use it. So this is really significant. Bill's kind of laid it out, and I think the bits that I would echo here, this is EU regulation. So we do a quick poll. Who's from the EU? Lots of hands, okay. So you won't be surprised if I tell you that this is pro-consumer more than pro-innovation, where they strike the balance. So you know where regulators are coming from, because there's a culture to the regulator and to the environment. So human dignity is a very significant piece of the policy behind this, and human in the loop is another significant piece of the policy behind it. Does anyone work in a regulated industry? I wasn't sure many hands would go. So not many, but some.
There's a guy down there who does insurance.
Okay.
We've got a doctor here. I'm not sure. What industry is this?
Yeah, it's interesting. Part of our organisation is effectively under the remit of the Gibraltar Financial Services Commission.
So finance. Okay,
There we
got you. Okay.
So Nick has found some people who, if it's not coming through on the mic for the streaming, are subject to financial regulation and medical regulation and similar. So there's a run-up to the EU Act. We've got almost a couple of years to prepare for it, but at that point, you're all subject to regulation. Working in a regulated industry is not like working in an unregulated industry, because you have the shadow of the regulation on everything that you're doing. It's like the regulator is looking over your shoulder. Whatever you're building, you have to take account of the regulator's view of that, the regulation's view of it. Because if you develop the most valuable tool imaginable, but the regulation prevents you from deploying it, then it's a fantastic theoretical project, but you can't have any customers.
To that, I would also add, if you develop something in the lab, as cool as it is, once it crosses over to downstream users who are going to try to productionize it, it's going to be subject to these rules, right? And that's, yeah, pretty intense.
Yeah.
So so then I think now we have a pretty good background. If you hadn't sort of looked into what the EU AI Act is, that's sort of a landscape sort of view of it. And one of the reasons why we're so interested in it is that it's probably going to be a precursor to other types of regulation that might evolve in other jurisdictions, the US, China, and so forth. And so are there any like immediate questions that people want to jump in on? And then we've got a couple of positions that both the gentlemen want to take. But let's just take a couple of quick questions.
I saw that hand first, and then maybe.
Let's go to Connor. Wait for the mic.
Thank you. I was wondering if anything related to like unlearning was in the act, unwinding models from having like certain people's data.
I could take that unless you want to jump. Well, quickly, what I'll say, one thing I didn't mention in the overview is this does not disrupt any existing regulation like GDPR. This coexists with it, right? So I think of unlearning as something that was heavily driven by GDPR and other data privacy rules. So everything in this act has to coexist with that. I'm not aware of anything new in the unlearning space. That certainly could happen. I haven't seen anyone talking about it. But just a heads up, like everything in GDPR still applies. So unlearning for the purposes of satisfying GDPR would still apply to everything being done here.
Exactly. I think it's your job to fix that stuff. So the regulator's not going to tell you what to do or how you should do things. So it's looking at the outcomes, because that kind of thing is what affects the users, and it's the thing that the regulators, from a non-technical perspective, can figure out. So as Bill says when he lays out the Act, the main provisions of the Act are identifying systems that are within the perimeter of the Act and then putting a risk classification over the top of them. So the practical effect of your question is, if you built a model using data that it was not legitimate to use, then you've got to retrain the model or junk the model. So the potential cost of ingesting data that is not permitted is enormous. And that's the piece from the investor perspective that we're particularly focused in, that people aren't investing into models that are going to be shut down and therefore valueless.
There's a gentleman in the blue. He had his hand up too. She's almost there. Otherwise, online can't hear.
So my question is, maybe can you explain a bit with the use case, like for example, like ChatGPT, which is actually developed in the US, and then we don't know actually what kind of training data actually they use. Maybe they didn't expose actually really fully the transparent, and it's still like controversy whether they actually have to be transparent for everything or not, and then how this EU AI Act might affect, like in EU, like here, for example, maybe in 1 or 2 years, maybe I cannot use the ChatGPT, or I don't know, like, have you thought about it, or?
That might be a good segue into this.
Yeah, okay. So I think we can address some of these topics actually just in a couple of positions we're going to introduce. So, Bill, do you want to just speak to your first position that you wanted to explain?
Sure, thank you. And I promise you I'm going to respond to that while I'm talking about this. Thank you for that question. So I've spent a lot of time over the last couple of months looking at the impact of this EU AI Act, specifically on federated learning. And we do, just spoiler alert there, we do have a paper that we put up on Archive that looks at this topic. Please check that out. At a high level, I would say there's a little bit of a conundrum. And when I describe this federated learning conundrum, I think you'll find that a lot of it also applies to other closed data scenarios, like, whether you use, Llama 2 or the OpenAI models. Okay. So here's the conundrum I'm talking about. I think, and Charles, I'm very interested in your thoughts on this as well. So the Act, certainly in its preamble or its recitals, which as a US trained attorney, I'm a little less familiar with. I don't think they're binding, but they kind of give you some context that could be become influential on later court decisions. But they make a big deal out of privacy. It's one of the 7 pillars of responsible AI that the Act is built around. And I even think in there's sort of an endorsement of systems like federated learning that help preserve privacy. So I know there's a lot of text right here. I'm going to read it because I think it's really important. This is in the recitals. And as I'm reading it, just think about how it applies to federated learning. It really does sort of sound like an endorsement of federated learning, but also a statement that the rules that apply to everyone else also apply to federated learning. The right to privacy and the protection of personal data must be guaranteed through the entire life cycle of the AI system. The principles of data minimization and data protection are applicable when personal data are processed. Hopefully everyone is familiar with personal data, protected in many other parts of the EU legislation. Measures taken by providers to ensure compliance with those principles may include technology that permits algorithms to be brought to the data and allows training of AI systems without the transmission of the raw or structured data. Sounds a lot like federated learning to me. Might fall in there. Without prejudice, however, to the requirements on data governance provided for in this regulation. So I read that last part as saying the same rules apply despite this sort of endorsements. And with that being said, so we sort of have this kind of endorsement, certainly of privacy and maybe of systems like federated learning that protect privacy by design. But then there's a lot of rules, and I think some of these we're going to have to all spend a lot of time thinking through how we make this work for systems like federated learning. And I'll be quick, and I'll just highlight 2 sort of buckets of rules. One is around training data. So the EU AI Act subjects training data to a number of requirements. Those have to do with training data governance, which has to be appropriate in various ways. Training data quality, so the training data has to be everything from relevant to complete in light of the purpose. It has to have the right representation. It has to be free of errors. It has to be free of data poisoning. So there's a lot of requirements around the training data itself. And that's all for high-risk AI systems. For general purpose AI models, it has to be documented. So, we all have to think, what does this mean in a federated learning scenario where the data is closed off to us by design? I think we all have to think about ways that we can capture data, information, I should say, about data governance, about the data quality, client side, and maybe pass that back to the central server in order to stay compliant with something like this, with a regulation like this. I'll highlight one other sort of interesting set of rules, or in this case, it's more like forthcoming rules. The Act commands some EU entities to work on energy efficiency rules. So these are kind of kicked down the road a little bit. We don't know what these are just yet until these entities refine them. But we could be looking at a world where there are energy efficiency standards. And similar to the situation with training data, it's fairly straightforward, perhaps in a centralized setting. But when you're talking about a federated setting where we have many different devices that are consuming energy in different ways, first of all, how can we measure energy efficiency on those devices? We'll have to have a framework for that. And then based on the standards as they come out, how do we satisfy them? How do we make these systems more energy efficient client side? So those are sort of, that's the conundrum that I would highlight. This endorsement of privacy, federated learning to some degree perhaps, but also maybe some hurdles that the research community has to think about technical solutions for.
Great. I think there might be a couple of questions in the room about this. Ruth, there were 2 questions just down here from these 2 gentlemen. I think one's on insurance and one I'm not sure what it's on, but I think it could be quite relevant. Let's see where we go with it. The mic's just coming over.
Yeah, my question is really more on the policing. So the EU Act exists for EU companies. What do you see, Charles, as the mechanism by which they're going to enforce it? And what do machine learning engineers and everybody else need to put into their code, into their documentation, into data governance and management and all the other stuff to be able to comply with the EU AI Act if they come after you?
That's a great question, and it's not a plant, although we do know each other. So I didn't know he was going to ask that. So broadly, this is, from our perspective, like how's it going to be enforced is a question for the regulators. They've got regulation, they've got courts. You can't determine, the bill's saying, we've got language here, and it can be interpreted different ways, particularly because it's all fact-dependent. So you would take your models or your systems, whatever you're building, all of these amazing things that are printed up around the building, and you apply the regulation as a framework across it. So the regulation is not responding to what you're building. It sits as a framework for you to interpret in relation to what you're building. Enforcement action can be brought by the regulators, but you'd find out if you have a difference of opinion on the terms of the regulation, you think that you've complied, the regulated things you haven't, well, ultimately, it'll be determined by a court. It will be extraordinarily expensive and take years. So that is not how we're going to have to do this. If you think about the legal system, you'll all be broadly aware of the fact that ultimately the court decides. We don't have the time or the money for the court to decide. There are so many questions. So it will be in communities like this, market practice, standards bodies, people producing papers. I think Nick has picked on Bill and I because we're the lawyers that think you're building the tools that address the problems that this type of regulation is trying to fix. So it's well known that we've got an online misinformation, disinformation problem of enormous proportions. And I'm struck by listening to other presentations in the room that you guys are sort of working towards federated learning in principle and what you're building specifically in practice. Exactly these questions. Bill's calling out what we call data minimization. So not using more data than you need to. The consent issue is around people's data only being used for purposes that they are familiar with. So purposes is a big theme around this and the data regulation, data protection regulation that the European Commission is interested in. I think the other thing that's going to sit behind it as well is I spend a lot of time these days on ethical AI, trying to understand what that means. So that is somewhat answering the question here. If you're building with a view to ethics and the user, customer, data subjects experience, the likelihood is you won't go too far wrong. And so we're building themes and adding detail to those around the ethical questions. So it's ensuring that folks like you don't need to be lawyers, but have got access to people like us and enough knowledge of what the policymakers are trying to do. So when you're building systems, you can recognize the sales opportunity because it's fixing an open question that's sitting out there. You're driving it at themes that the policymakers themselves have got.
Excuse me. I think perhaps we should get the other question here.
Yeah, hi guys. Like Nick mentioned, I work in a quite highly regulated financial industry, and if I propose federated learning at work, my privacy team says to me, are we allowed to do federated learning? What is the rules and regulations? So they're asking me, but I'm not an expert on regulation. I can build a federated model. Is there any regulation I can point them towards?
So shall I take this? The point that Bill makes about this regulation sits horizontally across the regulation that's industry specific and sits vertically. So you've got financial regulation, as you're aware, in relation to, in these areas, things connected to data protection. So if you're using data connected to an individual, then you need to be concerned about it. If you're using data that's not connected to individuals, then you've got more scope in relation to that. So depending on the nature of the financial services that you're in, if it is insurance, then you have a lot of you have a lot of personal data. So you're aware of that. And sitting behind that in insurance, this may not be widely known, but the same regulators that are building this kind of regulation are also saying we can't have the modeling too tuned because we're then importing biases. And the classic one in relation to insurance is between male and female drivers. So there are limits the regulators limit the ability of insurers to simply price risk in premiums. So to come back to your question, you're overlaying the rules here, financial regulation, and data protection. The federated learning is, I think, not a widely known topic. It is not something that the financial regulators, I think, have got a broad view on. So your ability to persuade your colleagues is somewhat dependent on your ability to persuade the regulator. They are open to this. There are sandboxes in the financial regulators in every jurisdiction. So I think one of the things I was going to say here is as a group here, we need to work together with people like Bill and I, giving signposts and also looping in the other people that can enable you to build these things out. But it won't radically change what you're able to do, other than in relation to topics where you're able to use data which is not identifiable to individuals. So if the systems that people have got in this room are adapting data to remove identifiability, then that's the thing that you're taking to your regulator and saying, hey, we're actually able to use data that we might have thought we couldn't because we can put it through these systems.
I just want to check if there's questions online. Pan, is there anything there? We've neglected them a little bit in the last couple of minutes. No? Okay. There's the guy with the microphone right now.
Hi, so I'm from healthcare. And recently, and especially post-COVID, there's been this conflict between the secure environment system on federal or national level, especially for health data, and then the other side of the coin where we have federated learning, secure aggregation, and then on the regulatory side we have the AI Act, European Health Data Space, that's also in the works. And my question is, as a medical doctor and as a researcher, I would like to have data not only from the point of care, from the hospital, from primary care, but also data from the patient outside of the system. What are their daily habits? How much are they doing in terms of physical activity? Are they taking their prescription drugs? So in this balance of the taking advantage of the unfair data distribution of FL, but also the needs and the wants of governments and regional governments, what do you think that in the coming years will come out of AI Act and other regulations?
I'll give a quick answer and give time to Bill. I think it has to come at a policy level. So I've worked with the UK Parliament since 2016, and through that time we've had some AI with medical data use cases that have caused concern in the wider population. So maybe repeating a little bit what I was saying before, federated learning, I think, is to a large extent the answer to that, and it is at a national level, because you'll hear some policymakers say that in the UK, where we have this sort of free at the point of delivery medical services, the one thing that people could use to pay for is their data. So if they're not contributing financially, they can contribute data, and that can be anonymized and managed in a very careful way. One of the difficulties that's often associated with it, and you'll know this for sure, you know what I'm talking about without naming names, large tech companies often sit behind the projects, and it becomes impossible to get through to the substance of it. It's drowned out in concern that's driven around the sort of the wider community connected to that name. So federated learning will take us away from that, and that's the direction that may make these things a bit easier to go forward with.
Briefly, Bill, do you want to add anything to that?
I don't have anything to add. Thank you, Charles. Really interesting question.
Well, actually, we were bang on time. So it just flew by. But that was great. I think we started to start a conversation in terms of understanding when the regulation comes, what are we going to do in terms of how we deploy models, how we research the field, and so on, because we will have to materially change. And the question will be, what tools will we use to navigate that situation? So I just want to say, well,
I make a final point just to say,
Okay,
so
okay.
my point is very practical. You know who I am because there I am. But I don't know who you are. So if you could connect via LinkedIn or whatever way you would, I'd really like to follow what you're doing, and to the extent I can help and support and bring lawyers. And not all lawyers tell you what you can't do. Some tell you what you can do. So find one of those.
My final remark, the paper that I mentioned was done in cooperation with IBM and TUM, Technical University of Munich, so please check that out if you can.
Those are two excellent last points. So thank you so much. Thank you.